I want to thank also the members of the public who've come out here and expressed their concerns and very passionately, argued for what they believe in and what should be happening to this property. But I'm going to be the bad cop in a sense because I am obligated to point out that none of the concerns that have been articulated here have anything to do with what's before this board. This board, there are legal standards that apply to the denial of a license, a junk license in this case. And there are two reasons for which this board can deny a license. The first was touched on by Attorney Azar, and that's the remonstrance. Now, as far as the remonstrance statute is concerned, the Supreme Court said, and this is a case Bork versus Dettori, the Supreme Court says that the statute clearly contemplates that the license will be freely granted unless there's objection with those within the 200 feet. That hasn't happened, so that's off the table. The second reason is that the applicant has to be unsuitable or unfit for licensure. And the Rhode Island Supreme Court has addressed that standard in a case involving a predecessor council. That was Novak versus City Council of Pawtucket. And in that case, the Rhode Island Supreme Court overturned the decision of the Pawtucket City Council that denied a secondhand shop license. The Supreme Court said that, look, a denial can be related to unsuitability or unfit for licensure, but it clarified what that meant. It said that must relate to the applicant's character or record as it relates to criminal activity. We applied to the police and received a clear BCI check. That was in compliance with the ordinance here. The Supreme Court also went on to say in that case that suitability applies to the person of the applicant and not to the proposed location of the business. Objections by neighbors relating to traffic hazards, depreciation of property, noise, dust, what have you, all the objections that we heard tonight. The Supreme Court said that's not suitability. That's not unfit for licensure. You have no business, there's no grounds for denial of a license of this type for those types of concerns. And again, I appreciate those concerns. I sympathize with them. But this board doesn't have the legal authority for those reasons to deny the license. But as this board and the oath that you took was to uphold the law. And here's what the law is. The law is that the interests of the constituencies have been expressed here tonight, as compelling as they are. As much sympathy as you may have for that, you're legally obligated to disregard that. So there's no evidence before this board. There's nothing in the record upon which the board can lawfully deny this license. And I know it's difficult, but if indeed that happens, then we'll be up in the Rhode Island Supreme Court again on a petition for certiorari, just like in the Novak case, and we'll be asking the Supreme Court again to overturn the council.
And we'll be asking the Supreme Court again to overturn the council. And we'll be asking the Supreme Court again to overturn the council.